thought that came to my mind was, I must talk to Namita as soon as I get to office. And I did, and in that very short conversation, it became amply clear to me that there was a lot to learn from Namita's understanding of the issues. And I pushed her to suggest that she'd do a talk for all of us so that all of us could learn from her thoughts, and it could also stimulate some dialogue amongst all of us to make sense of what is happening. So thank you very much, Namita, for agreeing to do this. I think this is, just from the fact that there's almost no room to sit now in this room, shows that we all really wanted to hear what you had to say about this. And I look forward to an exciting afternoon. We have about 45 minutes that you'll speak, or half an hour, 40 minutes, and then we can have a question and answer session.
Good afternoon, everyone, and thank you all for coming. Thanks also to Yamini for suggesting I give this talk and for agreeing to moderate today. My plan is to speak about the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Ordinance of 2014, which is a very long-winded title, so I'm going to refer to it as the Land Acquisition Ordinance of 2014 or the LARR. I might use the terms interchangeably. This ordinance, which was promulgated by the President a little over a week ago, has made substantial changes to the Land Acquisition Act of the same name, which was enacted in September 2013. So the ordinance came into force upon its notification in the Official Gazette on December 31st, 2014. And it sort of was notified very much towards the end of the day, just before midnight almost. So it sort of came in force pretty much as the year was dying. And it, as I said, substantially amends to the point almost of eviscerating the substantive content of the Land Acquisition Act of 2013. Now, this law was enacted in September 2013, but it was notified only on January the 1st, 2014. Now, the 2013 Land Acquisition Act came into being following widespread outrage in the last decade against the manner in which land had been acquired under the Land Acquisition Act of 1894 over the 65 years that it was in force post-independence, but these conflicts had intensified particularly in the last 2 decades. The enactment of the 2013 Act marked the end of a highly contested 6-year process of attempts to first amend and then later to repeal and replace the 119-year-old Land Acquisition Act of 1894. These attempts began sometime in 2007 following the agitation in Singur and Nandigram. I will describe the major changes that the 2013 that the ordinance brings about in the 2013 Act, and then say why I think that both the manner of promulgation of the ordinance and the substantive content of some of the changes made by it are deeply problematic. But before I do that, I want to say a little bit about the 2013 Act and the 1894 Land Acquisition Acts, as well as about land acquisition in India more generally, to put what I'm going to say into context for all of you. So the first question that comes to mind when we talk about land acquisition is, why do we have a law of land acquisition to begin with? The power of the state in a liberal democratic society to forcibly acquire land and other forms of property belonging to private individuals or held by them in common derives from what is often described in political and legal parlance as the eminent domain power of the state. Now, I'm using the word forcibly here quite deliberately because I think in the discourse surrounding land acquisition, we often do not emphasize enough that this is a forcible acquisition in that it is happening against the will of the individuals who are being deprived of their land and other forms of property. The state's power of eminent domain is inherent in the exercise of the state's sovereignty, and it allows the state to go about doing this forcible acquisition only upon the satisfaction of 3 conditions. The first condition is that such property may only be acquired pursuant to a validly enacted law, which is why we have the various land acquisition laws that I have mentioned. Secondly, such an acquisition must only be for a public purpose. And third, it must only be done upon the payment of just compensation. The first requirement, that of a validly enacted law, is there essentially to safeguard against arbitrary action by the executive. The twin requirements of public purpose and compensation are based on the rationale that no individual should have to disproportionately bear the burden of supporting the public good. So that's why we have a land acquisition law that empowers the government to acquire land for a public purpose and upon payment of compensation. So when we look at any law or ordinance, however complicated it might be, and the 2013 Land Acquisition Act is massive. It has 115 sections and 4 schedules. But the important thing to keep in mind are 3 things. How is public purpose defined in the law? What is the quantum of compensation prescribed for forcible acquisition? And what is the procedure that the government must follow in order to carry out this acquisition? These are the 3 things that are important for us to understand what implications that particular law has on the state's power to reshape property relations in society. The second point I want to note here is that the 2013 Act, just as the 2013 Act was a highly contested and negotiated piece of legislation which repealed and replaced the 1894 Act, the 1894 Act too was the product of a historical process of amendment, repeal and replacement of colonial legislation regarding land acquisition, which dates as far back as the Bengal Regulation the 1st of 1824. Why I'm noting this here is that we must understand that land acquisition has been a fairly controversial issue throughout the colonial and post-colonial period, and that attempts to repeal, amend, replace existing land acquisition laws are not new. Thirdly, the 1894 Land Acquisition Act was the most important, but only one of many laws of land acquisition that were enacted by the British pre-independence. Other such laws which allowed for land acquisition included the Land Acquisition Mines Act of 1885, the Indian Tramways Act of 1886, both of which are still in force. When the Constitution was adopted in 1950, the 1894 Land Acquisition Act and these other laws were also saved to the extent that it did not conflict with the provisions, with respect to the provisions contained in Part 3, the fundamental rights. According to the 7th schedule to our Constitution, which specifies the list of subjects on which the Union, Parliament and state legislatures can legislate, land was included as a subject in the state list. But the acquisition and requisitioning of property was included as a subject in the concurrent list, which enables both Parliament and state legislatures to enact laws for the acquisition of land. As the Indian state post-independence pursued a program of economic development and social redistribution, which involved the move from a feudal agrarian society to a mixed economy, capital-intensive industrial society, more than 100 land acquisition laws were enacted by both the union and state governments to achieve these goals. A majority of these laws were enacted in the first 2 decades post-independence and dealt with issues like zamindari abolition, slum clearance, town planning and development and resettlement of refugees following partition. Because these laws, both individually and collectively, significantly reshaped property relations in Indian society, they faced resistance both politically and through the courts from the sections of society whose property rights in land were eliminated through this process of land acquisition. These sections of society included landed elites like the zamindars, but in many instances included ordinary citizens in both rural and urban areas who had title to their land or personal dwellings. Over the last 65 years, acquisition of land under the 1894 Act and other acquisition laws enacted by Parliament and other state legislatures for the purposes of building dams, infrastructure and industry resulted in the massive displacement and dispossession of poor peasants and traditional communities like forest dwellers, cattle grazers, fishermen, and tribal groups. But following the 1991 economic reforms in particular, there was a surge in land acquisition by national and state governments keen on attracting foreign capital for dams, infrastructure, and industry. With the enactment of the Special Economic Zones Act in 2005, the acquisition of land by government for private industry, which had happened in an ad hoc manner in previous decades, became official government policy. The severity of the land conflicts during this period led to massive public outrage and civil society movements, which then translated into attempts for first amendment and later repeal of the 1894 Act. As it turns out, these conflicts have not abated because even as the 2013 Act came into force, a recent study done by the Rights and Resources Institute, which was reported in the Business Standard a few days ago, shows that there are more than 250 ongoing conflicts over land acquisition in 165 of India's 600 districts, which means that over 1/4 of all districts in the country have ongoing land conflicts pertaining to acquisition. So, what were the problems with the 1894 Act that led to such serious public discontent and created momentum for its replacement by the 2013 Land Acquisition Act? The working of the 1894 Act had revealed 5 major problems. First, the Act only recognized the rights and interests of land title holders. In doing so, it failed to take into account the interests of those who, while not holding title to the land, were nevertheless dependent upon the land for their livelihood. These included sharecroppers, tenants, peasant cultivators, cattle grazers, and forest dwellers. Second, the 1894 Act contained an inclusive and what became in practice an ever-expanding definition of public purpose for which both the central and state governments could forcibly acquire land. Moreover, courts consistently deferred to legislative determinations of what constituted a public purpose. In successive cases, the Supreme Court held that the expression public purpose was elastic and could only be developed through a process of judicial inclusion and exclusion in keeping with the changes in time, the needs of society, and the state of society. Courts also held that acquisitions benefiting particular individuals or entities could satisfy the requirement of public purpose so long as they were in furtherance of a scheme of public benefit or utility. Public benefit, too, was interpreted quite liberally by the court. As a result of such pronouncements, over time, the list of public purposes was continually expanded to include acquisitions for private industry, cooperative housing societies, and residential development, not necessarily for the poor, all of which were upheld as valid public purposes by the Supreme Court. Till date, I am not aware of a single case where the Supreme Court has found a law unconstitutional for violating the requirement of public purpose. The third problem derived from the legal requirement that persons deprived of their land and livelihood must be paid a fair equivalent of the value of their land as compensation. Unlike their approach on public purpose, the Supreme Court took the compensation requirement seriously, insisting in its early decisions that the compensation payable in case of compulsory acquisition must be the market equivalent of the value of the land. However, through a series of constitutional amendments, Parliament substantially ousted judicial review of the quantum of compensation that was payable in individual cases of acquisition. This resulted in a practice of payment of less than market value compensation in many, and in fact, perhaps most cases. The fourth problem related to the procedure involved in land acquisition under the 1894 Act. This was criticized for delays in the completion of acquisition proceedings as well as delays in the determination and payment of compensation by the government. It was also criticized for lack of transparency and people's participation in the government's decision to take over their land. This goes back again to the fact that this is a forcible acquisition, and so the procedure prescribed under the Land Acquisition Act allowed people to object to the acquisition. But if those procedures were either not followed or were followed in such a manner that the process was so delayed that the people really lost out, those were serious grievances against the 1894 Act's implementation. The fifth problem related to the misuse of the urgency clause to acquire land in non-urgent situations. Under the 1894 Act, the government could, in situations of urgency, which term was not defined in the Act, forcibly acquire land, bypassing most of the procedures for land acquisition prescribed in the Act. Over the past 60-odd years, successive national and state governments have notoriously misused the urgency clause for ordinary acquisitions merely to bypass the procedures prescribed under the 1894 Act. Moreover, judicial scrutiny of such acquisitions was also extremely deferential, with courts upholding the validity of the acquisition even when the government had failed to use the land that was urgently acquired many years later. So it is against this backdrop of the problems with the Land Acquisition Act of 1894 that let us assess the provisions of the 2013 Land Acquisition Act. This Act, I believe, remedied with varying success 4 out of these 5 main problems experienced with the functioning of the 1894 Act. I will start with the 2 problems it fixed best, then talk about the 2 problems it didn't redress as well, and end with the problems and challenges it created. First, by defining persons interested as those having an interest in the land, including tenancy and easement rights as opposed to actual title, an affected family as those dependent on the land for their primary source of livelihood, the law, the 2013 law, broadens the group of people to be compensated. Now, this had been a long-standing demand, noted by the Law Commission as having been voiced by the Bihar state government in 1958 when the Law Commission issued its report. So, more than 50 years later, the 2013 law actually did redress this demand to a significant extent. Second, the 2013 Act limited the invocation of the urgency clause to situations involving India's defense, national security, or for emergencies due to natural calamities, and any other emergency with the approval of Parliament. Given the effective parliamentary and judicial supervision, this would have greatly curbed the misuse of the urgency clause. Now, Mr. Jaitley has stated repeatedly in the press that the urgency clause in the 2013 Act made it impossible for the state to urgently acquire land for defense purposes except in case of an emergency. With all due respect, in my opinion, this is a clear misreading of the urgency clause as stipulated in the 2013 Act. So these were the two problems I thought the 2013 Act fixed well. Now coming to the things it didn't fix as well. Public purpose. The third problem the 2013 Act remedied to some extent was that of the ever-expanding definition of public purpose. The law had partially restricted the definition of public purpose by providing a much more detailed listing of public purposes. So public purpose includes all activities related to defense and national security, concerning the armed forces and other cases of public safety. That's one. Secondly, all infrastructure activities notified by the government, with the exception of private hospitals, private educational institutions, and private hotels, constituted a legitimate public purpose for which government could forcibly acquire land. That is, all infrastructure except for educational institutions, hotels, and hospitals. Land could also be acquired for industrial corridors, mining, urban and rural development, sports facilities, healthcare, transport, and space programs. The government could acquire land for these purposes for public-private partnerships as well as for private companies. Now, the reason why I say that the law only partially redresses this problem is because even though it gave a more restricted definition to public purpose as compared to what it was under the 1894 Act, which enabled the government to acquire land for any purpose the government deemed a public purpose, a substantial number of acquisitions are anyways done for infrastructure under the various land acquisition laws, and the law provides an inclusive, not exhaustive definition of the same. So at the time the law was passed, I had said that, infrastructure must not become to the 2013 Act what public purpose was to the 1894 Act. The fourth problem that the 2013 law tried to remedy to some extent was the provision of inadequate compensation for forcible acquisition of land. The law provides that the compensation payable upon acquisition would include up to 4 times the value of the average of registered sale deeds in rural areas and 2 times in urban areas. This amount includes the solatium, which is Latin for solace, the solace amount that was paid on top of the market value under the 1894 Act. Moreover, the 2013 law also provides for rehabilitation and resettlement awards. These awards include, for instance, the provision of a constructed house in place of the house lost through acquisition of land in certain cases. In certain cases, it also provides for the grant of land in place of the land acquired, but not in all cases. The compensation provisions of the law, as they were enshrined in the 2013 Act, failed to please anyone completely. Those speaking on behalf of peasants in traditional communities argued that given the rampant undervaluation of land and improperly maintained land records, those communities would still lose out on receiving a just compensation. On the other hand, those speaking on behalf of industry have criticized the compensation provisions, arguing that the law will make acquisition extremely costly and prevent industrial growth. Now, of course, acquisition will be more costly under the new law, but how much more costly it will actually be will vary from region to region. So, therefore, this sort of constant criticism that was made that this is just going to make acquisition impossible, I don't think there's enough data yet or studies done to actually support this claim. Similarly, the justness of compensation given under the Act would also vary from region to region. In some areas, I think this would actually amount to very good compensation packages. In some areas, I don't know. Again, the data is missing on how unjust or just it's going to be. Here, another thing I want to note is that the 2013 Act only sets the floor for the amount of compensation that must be paid for acquisition. State governments are free to amend the law to provide more acquisition, though judging by what they've done in the past, they have rarely done so. In fact, in the past, what we see is that acquisitions made under the 1894 Act are still more akin to market value compensation than those made under the state laws. The fifth problem that the 2013 law tried to remedy was the lack of people's participation in the government's decision to take over their land. The law introduced a procedure for social impact assessment of projects, which sought to ensure greater public participation in acquisition proceedings. The law also provided for the appraisal of the social impact assessment report by an independent expert group composed of social science experts and representatives of gram panchayats in villages. This body has the capacity to make recommendations, but such recommendations were not binding on the committee that would undertake the SIA, which committee was composed solely of bureaucrats. Now, there was a genuine concern voiced by industry as well as by peasants and traditional communities about the layers of bureaucracy that were added by the 2013 Land Acquisition Act in acquisition as well as rehabilitation and resettlement procedures. The effectiveness of these new procedures would depend greatly upon the effectiveness and the efficiency of the bureaucracy, as well as the capacity of the bureaucracy in different states to conduct such assessments. I don't know how this has really played out in the 1 year that the law has actually been in force, and I think it will be some time before we can say whether this provision actually served its purpose or created additional problems. Importantly though, the 2013 Act exempted acquisitions that were made under the urgency clause from social impact assessment. And so at the time the law was passed, I had said that careful public and judicial scrutiny of the urgency clause was necessary to prevent misuse. But because at least what the 2013 Act had done was to define urgency very restrictively, to include only 3 or 4 categories of cases, I'd hoped that this would actually prevent misuse. And finally, one problem that the 2013 Act created was that it exempted 12 laws, including the Electricity and Railways Acts, the Coal Bearing Areas Act, and the Land Acquisition for Mines Act from its compensation and rehabilitation provisions. There was a lot of contestation about this exclusion. The earlier list contained 16 laws, including the Special Economic Zones Act, which would have really negated the impact of many of the protective provisions of the LARR Act. The law, however, the 2013 law, however, mandated the centre to, within 1 year of the laws coming into force, to apply the provisions of the 2013 Act also to the acquisitions that were to be made under the exempted laws. Now, since the law came into force a year ago, there has been a lot of litigation and many cases that have been decided both by the Supreme Court and the High Courts under the 2013 Act. There have been over 16 decisions by the Supreme Court and the rest by various High Courts, in total 78 finally decided cases, as well as about 60 interim orders in ongoing litigation, which considerable litigation goes on to confirm the extent of conflicts over land acquisition that have also been reported by institutes like the Rights and Resources Initiative. So that's where we were at before December 31st when the ordinance was passed. So now let's talk about the ordinance. The ordinance makes several major changes and some minor updating or corrections to the 2013 Act. What are the major changes? The first change is that Section 10 of the ordinance brings the exempted laws within the purview of the compensation and rehabilitation provisions prescribed in the 2013 Act. Now again, like I did with the Act, I'm going to start with the positives. So this is a positive change. And this change actually explains the haste with which the ordinance was enacted. Because these laws, under the provisions of the 2013 Act, these laws would have come within the purview of the requirements stated in the Land Acquisition Act, in any case by the 1st of January 2015, the government basically has tried to claim the credit of bringing about this positive change, probably because this is the only positive change that the ordinance has really brought about. So the first positive is basically something that would have happened anyways. The second positive is a negative, in the sense that The second positive is that they have done nothing to change the compensation provisions. They've left it alone. So those are the only two positives that we have. Now let's come to the negatives. The negatives are the changes that it makes to the public purpose and procedure as defined under the 2013 Act. Now, Section 3 of the Ordinance allows acquisition by the government for private hospitals and private educational institutions, something that, as I mentioned earlier, had been specifically excluded by the Land Acquisition Act. And at least a lot of the media controversy had been about, things like the Adarsh Housing Society and so on, were really, it was exactly those kinds of things that they wanted to exclude from, the acquisition, forcible acquisition power under the Land Acquisition Act. But they've been brought back in. Private hotels are still out, but the other two are back. In another change, it allows acquisition not just for government, public-private partnerships and private companies, all of which was allowed under the 2013 Act, but also for private entities other than a company, which include proprietorships, partnerships and non-profit organizations. The next change is with respect to the procedure. Section 10A of the Ordinance allows the government to exempt any project under the following categories from the social impact assessment provisions contained in the Land Acquisition Act. In other words, bringing all such acquisitions really within the purview of the urgency clause, which allowed the government to exempt acquisitions from SIA provisions. What are these categories that have been exempted now? These include projects vital to national security or defense of India, including preparation for defense and defense production, so all defense industries. Rural infrastructure, including electrification, affordable housing and housing for the poor people, industrial corridors, and infrastructure and social infrastructure projects, including projects under public-private partnership, where the ownership of land continues to vest with the government. Read together, these categories, in my opinion, include most cases of land acquisition that need to be considered. So in effect, this provision has brought us back to the situation as it prevailed before the enactment of the 2013 Act, when both union and state governments notoriously misused the urgency clause to bypass the procedures for land acquisition prescribed under the 1894 Act.
Namita, can I just stop you for a small clarification? How would you read the fact that the earlier exempted laws were brought under the purview of LARR, and at the same time a whole range is exempted from the SIAs?
Yeah, so that's...
Is there a contradiction there?
No, because, the acquisitions under the exempted laws, they've been, they were the only laws under which the acquisitions were exempted and brought back under. But they've just gone ahead and created this fresh category. So there isn't a contradiction in the sense that the subject matter that the other laws were covering, like, the Electricity Act, the Railways Act, the Mines Act, it's different from what they've now brought back in. But in effect, they've basically, negated SIA for the vast majority of acquisitions. Next, the ordinance amends Section 24 of the 2013 Act, which referred to land acquisition proceedings that were initiated under the 1894 Act. Now, this section basically said that where land acquisition proceedings were pending, they had been initiated under the 1894 Act, and an award of compensation had been made 5 years or more prior to the commencement of the 2013 Act, and one of two conditions were satisfied, in that either the physical possession of the land had not been taken, or the compensation. So the award has been made, but the possession of the land has not been taken, or compensation has not been paid. And 5 years have passed since then. Then in that case, the acquisition proceedings would be deemed to have lapsed, and the government would have to initiate acquisition afresh and under the procedures which were now prescribed in the 2013 Act. Now, there has been and continues to be a lot of litigation on this particular provision. Out of the 16 Supreme Court cases that I reviewed, all of them were on this provision. So the ordinance is directly responding to and trying to stem the tide of litigation, seeking to quash proceedings that have typically taken an inordinately long period of time. And as I said before, that one of the big criticisms of the Land Acquisition Act was that you would use the urgency clause to bypass the procedures prescribed under the Act, but you would not finish the acquisition. And so, the people whose land was being acquired, they basically did not have could not participate in the process of acquisition, nor were they, benefiting from the compensation that they were entitled to receive because the procedures were not being completed. Moreover, the ordinance also says that in computing this period of 5 years, any period during which the acquisition was held up by a stay or injunction by the courts should be excluded. The ordinance further amends the Act that in cases where land acquired under the Act remained unutilized. So there was a provision in the Act that where land that was acquired under the Act remained unutilized for a period of 5 years after possession has been taken by the government, then the land must be returned either back to the landowners or their legal heirs in case they were dead, or to the land bank of the government. Now the ordinance amends this provision to say that if the land remains unutilized for a period of 5 years or for a period specified for setting up the project for which land has been acquired, whichever is later. Now it is not clear from this provision as to who is going to specify the time period for setting up this project. One would think that it is the government, but because the 2013 Act and the ordinance also allow for land acquisition by public-private partnerships as well as for private companies, it is not clear if the project proponent would also have some say in specifying this time period. So we don't know what it's doing, but what we do know is that through this provision, the ordinance is essentially protecting and condoning delay in completion of land acquisition procedures. Finally, in a move to protect bureaucrats from liability, the ordinance amends Section 87 of the Act, which made the head of any department of government liable for any offence under the Act which was committed by the department, by requiring that prior sanction of the government must be taken before the head of that department is actually prosecuted. So those are the major changes that the ordinance brings about. So let me conclude by saying that land acquisition is bound to be a contested issue in countries with land scarcity that are trying to achieve rapid economic development through a development model premised on capital-intensive industrialization. In that respect, India is no exception, and as we become more land scarce with population increases, we should expect land conflicts to intensify. The 2013 Land Acquisition Act was flawed. It had its fair share of problems, but it had its fair share of problems because it was essentially a contested compromise between various competing interests. But it was a step in the right direction for ushering in a culture of justification, wherein the government is required to engage with the people that it is dispossessing of their land and their livelihood, of the legitimacy and the necessity of that displacement and dispossession. What the ordinance has done by substantially amending, in my opinion, eviscerating the Act of its substantive content, is I think a very retrograde step, because I think first because it is extremely hasty. It took us 119 years to amend to repeal and replace the Land Acquisition Act. It's only been in force for a year, and perhaps it would have been a good idea to see what are the challenges and the opportunities that the Land Acquisition Act would have created for various competing interest groups as well as for the process of development. Instead of doing that, they've gone ahead to hastily amend the law, and also done it in a way by using the government's ordinance power. Ordinance making power under the Constitution is supposed to be used only for necessary and emergent conditions. It should be necessary and it should be emergent. And I'm not sure either of those conditions is satisfied here. That being said, the ordinance making power of the government has also been systematically misused over the last 65 years. Every government has done it. And so in that sense, this government is not doing something new. But with respect to this particular law, partly because it has been such a long time before this law, this law is basically repealing a 119-year-old law. It went through a 6-year process of contestation, of public consultation, and also consultation across political party lines to actually bring this law about. And within 1 year, you have substantially amended it. So in that sense, I do believe that the ordinance is a retrograde step.